Still on the Supreme Court judgment, in a recent interview on our flagship program Digi 360, legal expert Liborous Oshoma weighed in on the ongoing dispute in Lagos State, particularly highlighting the case of Ruth Vival, the Labour Party candidate in the 2023 gubernatorial election. According to Oshoma, a court ruling clarified that holding dual citizenship does not hinder one's eligibility to be a state governor as long as they were born in Nigeria. Expressing his perspective, Oshoma emphasized the need to bring an end to political litigation, urging politicians to gracefully accept defeat.
I think to a very large extent there should be an end to electoral litigation. I told somebody earlier on that the politicians should learn to accept defeat at the polls. This idea of going to court. I also would want to encourage INEC to ensure that as much as they can to elevate the practice of electoral transparency to a very high level so that it will breed trust in the process. That is what is breeding this attitude of going to court, wasting a lot of money on litigation, fishing for evidence and looking for loopholes to ventilate your frustration on your cases, even when there are none. It is crystal clear that the Electoral Act does not forbid for a governor, or somebody from a governor from contesting if you are a Nigerian by birth, whether you hold dual nationality or not. And that if you listen to that matter, if you follow that matter, some of the issues were not even whether he was a Nigerian, the deputy governor was a Nigerian, but that he pledged allegiance in his application for citizenship, that he pledged allegiance to another country. And that disqualifies him from contesting. The issue was not whether he was a Nigerian by birth. Both parties agreed that he was a Nigerian by birth. And then on the issue of the sacrosanct, timeline for electoral matters to be disposed of, some persons will look at it as a technical issue. They say, it's technicality. I've taken time to explain this consistently, that what people understand by technicality in the day-to-day rule, it's the position or it's the sacrosanct position of the law in electoral matter. That is why we say they are sui generis. Something that ordinarily would be a technical issue, and they'll say, don't base your decision on technicality in other matters. But for Electoral Act, it is not a technical matter, it is the rule. And that is why, if you are the tribunal, for example, and the 180 days for determining that matter lapse, what we do at the tribunal is to simply apply to court to say that this matter has come to an end. Any step taken now becomes an academic exercise. And so to that extent, parties should shake hands and go back home because the timeline for determining that matter had lapsed.